Complaining and fighting against bill collectors and CRAs. Chapter 1. Fighting the bill collectors and credit reporting agencies. Stop collection agencies. The Fair Debt Collection Practices Act says that a collection agency must stop contacting you after they receive a letter telling them to. The body of the letter should basically read: You are hereby notified under provision of Public Laws 95 to 109 and 99 to 361, also known as the Fair Debt Collection Practices Act, that your services are no longer needed. Your organization is to immediately cease and desist all attempts to collect this debt. I will deal only with the original creditor. Complaining about credit. First, try to solve your problem directly with a creditor. Only if that fails should you bring more formal complaint procedures. Here's the way to file a complaint with the federal agencies responsible for carrying out consumer credit protection laws. Complaints about banks. If you have a complaint about a bank in connection with any of the federal credit laws, or if you think any part of your business with a bank has been handled in an unfair or deceptive way, you may get advice and help from the Federal Reserve. The practice you complain about does not have to be covered by federal law. Furthermore, you don't have to be a customer of the bank to file a complaint. You should submit your complaint in writing whenever possible to the Division of Consumer and Community Affairs, Board of Governors, the Federal Reserve System, Washington, D.C. 20551, frb.gov. Be sure to describe the bank practice you are complaining about and give the name and address of the bank involved. The Federal Reserve will write back within 15 days, sometimes with an answer, sometimes telling you that more time is needed to handle your complaint. The additional time is required when complex issues are involved or when the complaint will be investigated by a Federal Reserve Bank. When this is the case, the Federal Reserve will try to keep you informed about the progress being made. The board supervises only state-chartered banks that are members of the Federal Reserve System. It will refer complaints about other institutions to the appropriate federal regulatory agency and let you know where your complaint has been referred. Complaints about other institutions. In the Credit Resources section, you will find the names of the regulatory agencies for other financial institutions and for businesses other than banks. Many of these agencies do not handle individual complaints, however, they will use information about your credit experiences to help enforce the credit laws. Penalties under the laws. You may also take legal action against a creditor. If you decide to bring a lawsuit, here are the penalties a creditor must pay if you win. Truth in Lending and Consumer Leasing Acts. If any creditor fails to disclose information required under these acts or gives inaccurate information or does not comply with the rules about credit cards or the right to cancel certain home-secured loans, you as an individual may sue for actual damages, any money loss you suffer. In addition, you can sue for twice the finance charge in the case of certain credit disclosures or, if a lease is concerned, 25% of total monthly payments. In either case, the least the court may award you if you win is $100 and the most is $1,000. In any lawsuit that you win, you are entitled to reimbursement for court costs and attorney's fees. Class action suits are also permitted. A class action suit is one filed on behalf of a group of people with similar claims. Equal Credit Opportunity Act. If you think you can prove that a creditor has discriminated against you for any reason prohibited by the Act, you as an individual may sue for actual damages plus punitive damages, that is, damages for the fact that the law has been violated of up to $10,000. In a successful lawsuit, the court will award you court costs and a reasonable amount for attorney's fees. Class action suits are also permitted. Electronic Fund Transfer Act. If a financial institution does not follow the provisions of the EFT Act, you may sue for actual damages, or in certain cases when the institution fails to correct an error or recredit an account, for 3 times actual damages, plus punitive damages of not less than $100 nor more than $1,000. You are also entitled to court costs and attorney's fees in a successful lawsuit. Class action suits are also permitted. If an institution fails to make an electronic fund transfer or to stop payment of a pre-authorized transfer when properly instructed by you to do so, you may sue for all damages that result from the failure. National banks are chartered by the federal government and have the word national or carry the abbreviation NA or N.SNT in their name. Tell them you will complain to the Federal Trade Commission, FTC. Federal Trade Commission, Pennsylvania Ave. and 6th St. NW. Washington, D.C. 20580. FTC.gov. To complain about a credit card issued by a national bank, go to Office of the Comptroller of Currency, 1301 McKinney Street, number 3710, Houston, Texas 77010. Fax, 713-336-4301. Federal Trade Commission, Consumer Response Center, CRC 240, 600 Pennsylvania Avenue, NW. Washington, D.C. 20580. 877 FTC HELP 877-382-4357. Complain about credit card companies by state. Every state has an Attorney General's office which might have a consumer complaint office in it, or the state consumer office might be an entire department by itself. Complain about credit cards at this office. NAGI.org, a list of offices of state attorneys general. Chapter 2. Filing credit disputes. Filing disputes with the CRAs. There is usually a dispute form with your credit report. You can file billing disputes online. Experian.com/disputes. Investigate.equifax.com. TransUnion.com/investigate. Injunctive relief. You can seek injunctive relief that forces credit bureaus to stop reporting negative credit information from your file. Injunctive relief is an effective legal maneuver that can permanently remove damaging information from your credit report. You will, however, probably require the services of an attorney. This is how it works. If you can clearly demonstrate that information appearing in your credit report is inaccurate and is damaging your character, credibility, or ability to obtain credit, you can seek injunctive relief through the courts. Once relief is granted, a judge can order a credit bureau to immediately stop reporting any damaging information appearing in your credit report as outlined in the order, until such time as a trial or investigation is conducted. After you or your attorney succeed in persuading a judge to issue an order for injunctive relief, you will have from that moment on until the conclusion of a trial or investigation to obtain new credit. Credit histories and records. Your credit report contains information that says who you are as a person worthy of paying money that you owe. It has 4 things on it: name, address, employment, homeowner or renter. Past credit history. Public records knowledge like bankruptcy, lien, civil court judgments, child support payments. A list of people who requested your CR for the past 2 years. On your first attempt to get credit, you may face a common frustration. Sometimes it seems you have to already have credit to get credit. Some creditors will look only at your salary and job and the other financial information you put on your application. Most also want to know about your track record in handling credit, how reliably you have repaid past debts. They turn to the records kept by credit bureaus or credit reporting agencies whose business is to collect and store information about borrowers that is routinely supplied by many lenders. These records include the amount of credit you have received and how faithfully you have paid it back. Here are several ways you can begin to build up a good credit history. Open a checking account or a savings account or both. These do not begin your credit file but may be checked as evidence that you have money and know how to manage it. Cancelled checks can be used to show you pay utility bills or rent regularly, a sign of reliability. Apply for a department store credit card. Repaying credit card bills on time is a plus in credit histories. Ask whether you may deposit funds with a financial institution to serve as collateral for a secured credit card. Some institutions will issue a credit card with a credit limit usually no greater than the amount on deposit. If you're new in town, write for a summary of any credit record kept by a credit bureau in your former town. Ask the bank or department store in your old hometown for the name of the agency it reports to. If you don't qualify on the basis of your own credit standing, ask to have someone co-sign your application. If you're turned down, find out why and try to clear up any misunderstandings. The following laws can help you start your credit history and keep your record accurate. The Equal Credit Opportunity Act gives women a way to start their own credit history and identity. The Fair Credit Reporting Act sets up a procedure for correcting mistakes on your credit record. Under the Equal Credit Opportunity Act, reports to credit bureaus must be made in the names of both husband and wife if both use an account or are responsible for repaying the debt. Some women who are divorced or widowed might not have separate credit histories because in the past credit accounts were listed in their husband's name only, but they can still benefit from this record. Under the Equal Credit Opportunity Act, creditors must consider the credit history of accounts women have held jointly with their husbands. Creditors must also look at the record of any account held only in the husband's name if a woman can show it also reflects her own creditworthiness. If the record is unfavorable, if an ex-husband was a bad credit risk, she can try to show that the record does not reflect her own reputation. Remember that a wife may also open her own account to be sure of starting her own credit history. Mistakes on your credit record, sometimes mistaken identities, can cloud your credit future. Your credit rating is important, so be sure credit bureau records are complete and accurate. The Fair Credit Reporting Act says that you must be told what's in your credit file and have any errors corrected. If a lender refuses you credit because of unfavorable information in your credit report, you have a right to the name and address of the agency that keeps your report. Then you may either request information from the credit bureau by mail or in person. You will not get an exact copy of the file, but you will at least learn what's in the report. The law also says that the credit bureau must help you interpret the data because it's raw data that takes experience to analyze. If you're questioning a credit refusal made within the past 30 days, the bureau is not allowed to charge a fee for giving you information. Any error that you find must be investigated by the credit bureau with the creditor who supplied the data. The bureau will remove from your credit file any errors the creditor admits are there. If you disagree with the findings, you can file a short statement in your record giving your side of the story. Future reports to creditors must include this statement or a summary of it. Sometimes credit information is too old to give a good picture of your financial reputation. There is a limit on how long certain kinds of information may be kept in your file. Bankruptcies must be taken off your credit history after 10 years. Suits and judgments, tax liens, arrest records, and most other kinds of unfavorable information must be dropped after 7 years. Your credit record may not be given to anyone who does not have a legitimate business need for it. Stores to which you are applying for credit or prospective employers may examine your record, curious neighbors may not. A bad credit report. You are entitled by law to correct any inaccurate information that appears in your credit bureau file. If a creditor rejects your application because of negative information in your credit bureau report, it must identify the credit bureau involved. At your request, the credit bureau must disclose the contents of your credit file. If you act within 30 days of being turned down, there is no charge for this service. Check to see whether the information in your credit report is accurate and complete. You have the right, under the Fair Credit Reporting Act, to dispute the completeness or accuracy of any information in your report. When you do so, it helps to tell the credit bureau, in writing, why you think the information is not correct. Unless your dispute is frivolous or irrelevant, the credit bureau then must reinvestigate the matter. The credit bureau must correct any information that it finds is not reported accurately. Information that cannot be verified must be deleted. If you disagree with the results of the credit bureau's reinvestigation, you may file a brief dispute statement explaining your side of the story. At your request, the credit bureau will note your dispute in future credit bureau reports. Be aware that when negative information in your report is accurate, only the passage of time can assure its removal. Credit bureaus are permitted by law to report bankruptcies for 10 years and other negative information for 7 years. There is nothing that you or anyone else can do to require a credit bureau to remove accurate information from your credit file until the reporting period has expired. Don't be misled by ads aimed at people with bad credit histories, judgments, or bankruptcies. Promises to repair or clean up a bad credit history can almost never be kept. If you are having trouble paying your bills, you may be tempted to turn to a company that claims to offer assistance in solving debt problems. Such businesses may offer debt consolidation loans, debt counseling, or debt reorganization plans that are guaranteed to stop creditors' collection efforts. Before signing up with such a business, investigate it thoroughly. Be sure you understand what services the business provides and what they will cost you. Do not rely on oral promises that do not appear in your contract. Also, check with the Better Business Bureau and your local consumer protection office. They may be able to tell you whether other consumers have registered complaints about the business. Consumers who turn to such businesses for help sometimes encounter additional problems. Debt consolidation or other large short-term loans may have high hidden costs and may require your home as collateral. An unscrupulous company may misrepresent the terms of such loan agreements. If so, you could end up losing your home. Businesses offering debt counseling or reorganization may charge substantial fees or a percentage of your debts but fail to follow through on the services they sell. Some may do little more than refer indebted consumers to a bankruptcy lawyer who charges an additional fee. Businesses advertising voluntary debt reorganization plans or Chapter 13 relief may fail to explain that Chapter 13 debt adjustment actually is a form of bankruptcy. To qualify for it, you must have a source of regular income and a plan for repaying your creditors that meets the approval of the bankruptcy court. Businesses that sell bankruptcy-related services may not tell you all that is involved or assist you through what can be a complex and lengthy legal process. Be careful. These guys know you're desperate and will try to exploit that.